Good afternoon, everyone. Ms. Hammond, would you read the roll, please?
Here.
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 Thank you. Thank you. Yes, we are ready to proceed. I'm going to read this. I'm going to read the procedures into the record. This hearing is being held pursuant to Section 11-46 of the City Code. The parties have the right to make arguments, present evidence, exhibits, and/or testimony, and cross-examine any adverse witnesses. A party may be represented by any counsel of their choosing who is admitted and in good standing in at least one state. The rules of evidence shall not apply except as to privilege, but may be considered as a guide toward full development of facts. The license inspector shall present first, followed by the business and a short reply by a license inspector. The time limits in minutes are 30, 30, 10, with additional time being allowed per City Council discretion. The City Council may take the matter under advisement after hearing from the parties or may vote upon the appeal at the conclusion of this hearing. The City Council shall, by majority public vote of the members present, render a written decision based on findings of fact and the standards in Chapter 11, Article 2 of the City Code. In doing so, City Council may consider any proposed orders tendered by the parties. And
Okay.
who are we recognizing first? Is that Mr. Balthaser? Okay, council will recognize Mr. Balthaser for presentation.
Good afternoon. Thank you, Ms. Devine and mayors of City Council. My name is Pete Balthaser. As you know, I have been representing the City of Columbia along with Scott Bergthold, who is here today, on various legal appeals or legal challenges brought by Cricket Store 17 against the City of Columbia over the years. Mr. Bergthold and I, along with the City Attorney's Office, have been advising the Business License Division on various business license issues as well. And we are here today to represent the Business License Division in the appeal brought by Cricket Store 17. Pursuant to those procedures that were just read by you, Ms. Devine, I would ask that Scott Bergthold at this time be given permission by council to appear before you to present this matter on behalf of the Business License Division. Mr. Bergthold is admitted as a member of the bar in three other states, and we would just ask, as an out-of-state attorney, he has been participating with me. I am a member of the South Carolina Bar, just that he be given permission to make a presentation on behalf of the Business License Division.
Okay. Is there any objection?
No.
Seeing none, welcome, and you can proceed.
I take that I do have permission to appear?
Yes, sir.
And I will do it as gently as I can relative to the microphone. If I may approach, I have an exhibit.
Yeah, they're going to
I have an exhibit booklet that I'd like to give to each member of the council that will help guide through the proceedings. I'll
Okay.
provide a copy for whoever is here on behalf of Cricket Store as well.
And just for the record, is there anyone here representing Cricket Stores? Okay. If you'd like to sit here, you may. Thank you.
Thank you.
Here for Mr. Davis as well.
One more. One more. One more.
Scott, one more for Mr. Davis.
Good afternoon, Mayor Pro Tem and members of the council. I'm here on behalf of the Business License Division, and basically what we'd like to do is walk you through the appeal, the position of the Business License Division on this appeal. That's basically going to be facilitated by the binder in front of you. If you open it up, essentially, I could probably...
We're sorry for that, yeah. Well, we need to make sure it's recorded for the record, so we will just try our best to...
I could also sit at table and maybe speak into that microphone. If you would like, I could sit at table
Yeah,
and speak
can we-
into that microphone maybe.
You want to? Yeah, we can do that.
How is that? Is that any better?
Yes.
Okay.
Justin, are you getting the recording? I think so. Yes, sir, that would work. And I guess, just for purposes, since we've had these difficulties, can we restart his time to make sure that we have ample time?
Okay, I restarted my timer at 30 minutes, at least on my iPhone. I'm here on behalf of the Business License Division, and what I'd like to do is just talk you through the documents and the decision before you, give the business an opportunity to speak, and then I'll take any rebuttal or cross-examination necessary. Inside the binder, what I'm going to be asking the council to do, at the end of today, is to make a motion to adopt a written decision. That motion is on the left inside the binder, as well as a one-page written decision behind it. Basically, that written decision is the relevant provision of the Business Licensing Code on business license denials, which is Section 11-44, and then the 4 reasons that were laid out in the Business License Inspector's denial letter that's dated October 14th, 2019. Over on the right-hand side is a certification that essentially acts as a table of contents for the materials that I'll be presenting. This was signed by Ms. Shannon, the Business License Administrator, where she certified that the following documents are public records contained in the Business License Division's files and relate to the business license application of Cricket Store 17 LLC DBA Taboo. There are 10 documents there. In addition to those 10, I would also like to make a part of the record. At the back of all of these exhibits in the binder are 2 other documents that were sent to the Business License Department some time ago in 2016 from Jeff White, the owner and proprietor of Cricket Store LLC. There's 2 emails there to city officials, and then finally are the certificates of good standing that Mr. Balthaser talked about regarding my admission in other states. And at this time, I would offer this binder of exhibits into the record.
Okay. Is there any objection? No. Seeing none, we will admit this exhibit into the record.
What I'd like to do is simply start with number 1 in the tabbed binder. Essentially what this does is go through the relevant provisions of Chapter 11, Article 2, which is for business licensing in the City of Columbia. Very simply, Section 11-31 requires every business to have and obtain a business license and pay a fee every year for having that business license. The next section is 11-35. Subsection D says that when business license applicants seek a license, they have to provide proof of payment of any business-related fees, assessments, and or personal property taxes, including any late fees or penalties. The next relevant section is Section 11-44, the denial provision. It says the license inspector shall deny a license to an applicant under this article when the application is incomplete or contains a misrepresentation, false or misleading statement, evasion or suppression of a material fact, or when the activity for which a license is sought is unlawful or constitutes a public nuisance. If you turn the page over, these are all tabbed, but we also have a consecutive page numbering in the lower right-hand corner. So sometimes within a tabbed exhibit, I might need to refer to that Bates number or that consecutive pagination. The next provision is Section 11-45. This deals with suspension or revocation of a license, and subsection A gives the license inspector the authority to revoke a license if a licensee has engaged in an unlawful activity or nuisance related to the business. We're in a unique situation here because we've had a business that's been operating in the city of Columbia for some time, but at least for the last 5 years, from 2014 on, has never had a valid business license. So had they had one, they would have been subject to revocation for some unlawful activities that I'll talk about in a little bit. But it's just sort of one of the standards. But the main standard is 11-44. That's what we hear on the denial. And then finally, the last section at the bottom of the page is 11-46, which governs our appeal. And the procedures have already been read into the record. So I think we're covered on that. So that covers tab 1. Tab 2 now, we turn to the application that was filed by Cricket Store 17, LLC, on 9/13/19, that's September 13 of this year. They listed the business start date as September 13, 2019. And then I highlighted, put a box around their description of the business as general retail. And then we have some additional information from the applicant. They say that they have read the rules and the code requirements in the city. They also make some arguments that I'll get to later about the types of devices that they sell in the store. But number 2 in the tabbed binder is the application. Number 3, moving quickly through this, is the letter dated from the Business License Division October 14th, 2019. And it has several paragraphs. And essentially, the first paragraph says, it's been unlawful to be a sexually oriented business at that location, 4716 Divine Street, since January 2, 2014. Despite your repeated misrepresentations in many applications and court proceedings, Taboo has continued to unlawfully operate as a sexually oriented business at that location for more than 5 years. And then the next paragraph talks about 2 things relevant to today. One is on March 8, 2018, the Richland County Common Pleas Court permanently enjoined Taboo from operating a sexual device shop at their location. And then more recently, just this summer, near the end of July 2019, that court found you, Mr. White, your store, Taboo, and your manager, whose name is Larry Boyer, in contempt of court for operating unlawfully and in violation of the permanent injunction. In doing so, the court rejected arguments that the intended use of Taboo sexual devices or the storage age policy somehow exempted it from the ordinance and the court's injunction. The court ordered Taboo, specifically the LLC here today, Cricket Store 17, DBA Taboo, Jeff White, its owner, and Larry Boyer, its manager, to pay a $28,500 fine as a penalty for their unlawful operation of the business as a contempt sanction. But despite the law and the court's orders, Taboo has repeatedly continued to unlawfully operate a sexual device shop at that location. So that's the background. For the following reasons, under Section 11-44 of the Code, your application is from 2019 is denied. It quotes Section 1144. I won't read that again, as we've already read that into the record. But it says you can deny a license for misrepresentations, false statements, failure to include a material fact, and so forth. If you turn over to the top of page 2 of that letter, which is page 8 in the binder, it gives several reasons why this application is being denied. First, the application filed on behalf of Cricket Store 17 LLC states that, quote, the business start date, end quote, is 9/13/19 or September 13, 2019. That is a false statement, which is one of the grounds for denial of a license under Section 11-44. The city records show that Cricket Store 17 LLC started business in the city of Columbia in 2011. So ground 1. Second ground. Additionally, as prior applications have done, the present application misrepresents Taboo's business, saying it's not a sexually oriented business, but that it's a quote-unquote general retail business. But as in the past, recent observations reveal that Taboo is continuing to regularly feature sexual devices, such as dildos, butt plugs, anal beads, and vibrators, which are terms in the ordinance, and is doing so in many of the ways that the court in 2019 found in its recent contempt order. And then the next statement, the next paragraph says, the application also states that, quote, all remaining devices clearly identify on the packaging that the device is designed for novelty use by the manufacturer, end quote. That is also a misleading statement and a separate ground for denial, because Taboo sells devices that are designed manifestly for masturbation and stimulating the male or female human genitals anus, buttocks, and female breasts. Again, that's language from the sexual device definition in the ordinance. And contrary to taboo's representation, many of these devices, in fact, I don't know if any of the devices have the words designed for on the packaging, like Taboo put in quotes in their materials when they submitted their application this year. Even if the term novelty appears in small print on the package, that does not change the fact that the device itself is designed for sexual stimulation or sadomasochistic use or abuse. That's language from the ordinance. In fact, many jurisdictions regulate sexual device shops using the term adult novelty store. And then it says in the next paragraph, as in the past, Taboo has continued to regularly feature sexual devices such as vibrators, butt plugs, anal beads, and dildos. Taboo's operation of a sexual device shop violates the following Columbia City Code sections: 11-734A, which requires a license of sexual-oriented businesses; 17-374B, which is the zoning ordinance specifying zoning districts for these uses; and 17-374C, which governs the proximity of sexually oriented businesses to sensitive land uses like schools and residences and so forth. Therefore, or thus, Taboo's operation is unlawful under two sections of the city code, both the SOB licensing ordinance and the zoning ordinance. It therefore constitutes a public nuisance. Finally, the fourth ground of denial was under section 11-35D, which is one of those sections up at tab 1. A business seeking a license to operate in the city shall be required to submit proof of payment of any business-related fees, assessments, and or personal property taxes, including any late fees or penalties. Taboo was recently penalized for the unlawful operation of its sexual device shop, resulting in a $28,500 fine. This penalty relates to the operation of Taboo's business. Taboo's application is also denied because it lacks proof that Taboo has paid this penalty. So those are the four grounds for denial. And then what follows is tab 4 is the business application for an appeal or a written letter for a request for appeal, where they also get into settlement of litigation, all that stuff. I won't get into all that. I'll let them talk about that. Number 5 is something that's referenced in the beginning of the Business License Division's October 14th denial letter from this year, where they said you've made repeated representations in the past. Well, what they're referring to is all the times over the years that they've come in and said we're a general retail business, and then the city has done an investigation, found out that's not true, and then the court, in granting an injunction, has agreed with the city, and then in granting contempt sanctions, has also agreed with the city. So that happened once. It happened several times, but the three that are included here are in October 2014. At the bottom of the page, you can see they made a representation of being a general retail store, but the investigation showed that wasn't true. You flip over to the next page, May 11, 2018. Again, a letter where they're making the same claim, and that was found not to be a truthful statement, and their application was denied. So they came back. If you turn over to page 16 in the consecutive pagination in the lower right-hand corner, the very next month, in June, they came in again, and our people went out and took pictures, so on and so forth. Again, false representation of what the store was about, claiming that they were in compliance. If you turn to tab 6, we're moving through this packet, hopefully at a judicious pace. I won't go through all the details of this permanent injunction order that was entered by the Circuit Court or the Common Pleas Court on March 8th of 2018, but briefly they say, in 2011, Plaintiff Cricket Store, LLC, obtained a general business license and opened and began operating Taboo. Well, we know that they started in 2011, therefore the claim that their business start date is 9/13/19 is a false statement. But it goes through how Taboo sued the city in federal court on page 20, but was unsuccessful all the way to the U.S. Court of Appeals for the Fourth Circuit. They came in here on a BZA claim. They sued to challenge the Board of Zoning Appeals decisions that they were an adult use or sexually oriented business. Those were also rejected. At the hearing on the injunction, they made claims about what about Spencer's and all these different things. Well, the court looked at page 22 at what they sold. Brian Cook, the prior zoning administrator, the pictures he took, the websites that they displayed that were associated with the store where they featured sexual devices and so forth, looked at the definitions, and then moved on to basically say that at page 24, Taboo is clearly violating the zoning ordinance provision on multiple counts, and then issues a permanent injunction. So we had hoped that Taboo would stop their illegal practices, but unfortunately we found out they didn't. So we came in, and tab 7 here is the order finding Cricket Store 17 LLC, Jeff White and Larry Boyer in contempt of the March 2018 permanent injunction order. And the court, at the bottom of page 26, finds them in criminal contempt as well as civil contempt. If you turn over to page 27, basically Judge Newman just recounted all the failed challenges to the ordinance in federal court and in state court. And in that penultimate paragraph, the second to the last paragraph on the page, said photographic evidence of sexual devices prove that Taboo is a sexual device shop, i.e. a commercial establishment that regularly features sexual devices. And again, goes through rejecting arguments about age and things that they thought would take them outside the scope of the ordinance and the court's injunction. Finally, if you turn over to page 11 or 36 in the lower right-hand corner, at the bottom paragraph where the highlighting says the court already rejected Taboo's claims about unequal treatment, Spencer's and so forth, and the court was not going to rehash that ground. So the most important finding is at page 40, at the bottom where it's highlighted. It says, the court finds beyond a reasonable doubt that Taboo, White, and Boyer willfully violated the injunction order and are thus subject to criminal contempt sanctions. The court imposes a fine of $28,500 on Taboo, which is Cricket Store 17 LLC, White and Boyer, and they're jointly and severally liable to pay that amount. Also held them in civil contempt to pay a $15,000 fine if they continue to violate the court's injunction. So now that's kind of all of what the Business License Division was aware of. And then in this circumstance, they went out, they had an investigator, a private investigator go in like they did during the litigation, gather evidence, and this is what was found. They have the Taboo website. This is at taboosc.com. And go to the website, and it says Shop Now. You click on the page. It goes to adults only. You turn the page to page 45, and it says, warning, you're about to enter an adult store. And it warns of sexually explicit material. It says, if you're not yet 18 on the next line under that second highlighting, if you're not yet 18, do not enter this site. Where it says, by entering this site, I agree to the following. 1, the first bullet point, I am at least 18 years of age. And then at the bottom, I've highlighted they have a 2257 compliance statement. That's a congressional statute about keeping records about people who participate in sexually explicit films. So if you turn over, you'll see the home site of that page, which is tabooadultstore.com, all the sexual devices that are offered for sale on the front page, on the second page. These are the same websites that Judge Newman talked about in her injunction order in 2018 and her injunction order or contempt order in 2019 as what shows they're continuing to operate a sexual device store. And then if you turn over to tab 9, we have a receipt, and it shows that up in the upper left-hand corner, I've highlighted the date of the receipt when the investigator went in. He bought these items on 10/10/2019, October 10th of this year. And right there at the top, it shows their website, taboosc, which is the website back in tab 8 that has a picture of the store and the address 4716 on the old Taco Bell building. And then at the bottom, it has tabooadultstore.com, another place you can buy these materials. It's got 5 different items that were purchased there on the receipt. Turn over, I'm not going to go in great detail on each of these sexual devices that were purchased at the store, but essentially these 5 devices are all designed very clearly for sexual stimulation. There's little doubt with the language that's on the devices, this AirTouch device. But at the end, we took pictures of all sides of the packaging, and then at the very end of each device, we went to the web page and searched for that same device that the investigator bought in the store last month and found that every single one of the devices he purchased corresponded to what they sold and promoted and featured on their website. So there were 5 of them, clitoral stimulators, anal plugs, and devices, and vibrators, and all kinds of what you would expect, some bondage material, some pleasure tape, like a fetish pleasure tape. Again, these are all the types of devices that have been found to be sexually related devices or designed for sexual stimulation or bondage-type activities, which in the ordinance are classified as sadomasochistic use or abuse of oneself or others. So we confirmed that all those devices that the investigator purchased last month were ones that they had in the store, of course, and then also were featuring on their website. Finally, if you turn back to 10, Exhibit 10 in the tab, this is just a document that compiles a number of cases that basically show that adult novelty stores are sexual device shops. I mean, they're basically interchangeable terms in the case law. 3 of these cases, the Heidemann versus South Salt Lake City case, the Dr. Johns versus City of Roy, Utah case, the Littleton, Colorado versus EJ Gifts case. Those are all cases in which our firm wrote the ordinances for the cities. We were involved in 2 of those cases, including the one that went to the U.S. Supreme Court at the bottom there. And so saying that something's a novelty doesn't mean it's not designed for sexual stimulation, which is what the ordinance is triggered by. And so that was also something that business license officials had. And then finally, at the very back, I just want to say that the history that is maybe not well known to the council other than news articles or what they may have read about court decisions and so forth is the protestations of the business saying, hey, we're totally in compliance. It's been going on for years. So the next email is an email from Jeff White, the owner of Taboo, to Brian Cook, the zoning administrator back in 2016, as well as Roger Myers, the business license administrator at the time for the city of Columbia. And effective February 5, you see the highlighted sentence, effective February 5, 2016, Taboo is no longer a sexual device shop and or an adult video and bookstore according to your zoning definitions. If you turn over to the next email, which is the following month, again from Mr. White, written on Tuesday, March 29, 2016. He says, in the first paragraph, I have decided to purge every single sexual device in the store. On the second page, he says, I have ceased featuring sexual devices completely. So this has been going on for a long time, and so it was reasonable for the business license officials, certainly with what was before them and what was in their files, to not believe an applicant that's repeatedly been found to have made false representations to the city and has been found to have operated illegally for some time in the city of Columbia. And for all these grounds, we would ask that when the council deliberates, we would ask that even today they would make a motion to adopt the written decision, which basically just says a hearing was held. These are the standards in 11-44. These are the 4 grounds or 5 grounds for denial. And then it has the decision and a place to date and sign for the members of the council who are present. And at this time, I see I have 8 minutes left, but I guess I have a little bit of time for rebuttal anyway, so I'll ask the council to uphold the decision of the business license officials, in this case to deny a business license to Cricket Store 17 LLC. I appreciate the council's endurance for a somewhat long presentation, but I wanted to give the full background, and this time I would yield the floor to the applicant.
Thank you for that presentation based on business license. I know we are taking testimony, evidence, and cross-examination. Is there any question by a member of council before we move forward to the business?
I do.
Mr. Fedor?
And I just want to clarify to the record, and I know this has been going on since 2011, and there's many attempts by the city and the store to mislead the city and inspectors and the facts, and that's been documented, well documented into your presentation. So it's fair to say that this has been going on for a long time, and it's time to put this to a rest. So, thank you.
Okay. All right, then we will proceed to the presentation of evidence and arguments by the business. Just back to, apologize. Mr. McDowell?
Store. The overall thing that Taboo was pronouncing, the general underlying of the top edge of this conversation was that it's a general store.
That is the argument that essentially they are making and that they have been making since 2016.
But
And the store, just for clarity for the record, is Cricket Store 17 LLC. And it does business as Taboo. That's correct. And that's what their argument was. That's what their argument was in the courts on the injunction too.
okay.
Thank you. Okay, we will move to the presentation of evidence by the business. Just a reminder that you have 30 minutes for your presentation. If you would just state your name for the record, and then you can proceed. Thank you.
Yes, ma'am. My name is Cheyenne Wiseman, and I am the manager.
Yeah, she has her mic on. Ms. Weitzman, if you just project a little bit
Yes,
more.
ma'am. My name is Cheyenne Wiseman, and I am the manager of Taboo. Larry Boyer no longer works there, and I've taken over his position. I am not legal representation for Taboo. I was asked by the owner to appear in his place. I'm not sure where our lawyers are. I'm not sure why they aren't here. I was just asked to be the face of the store. I have no legal representation. I have no legal education or anything. I've just asked to appear as the face of the store.
Okay, thank you. We thank you for being here, and we will just note that legal counsel that has been part of it is not present at this hearing. Is there any statement on behalf of the store that you'd like to make in response to the Business License Department case?
No, ma'am, I wasn't given one.
Okay, thank you so much, and we
you.
appreciate you being here.
Yes, ma'am, thank you.
And so will you yield the rest of your time?
I'm sorry, what was that?
Will you yield the rest of your time? You had 30 minutes, so just say
Yes,
yield.
ma'am.
Okay, thank you. So with that said, we've had the business license present their case. The business itself is here. Mr. Brookthorpe, do you want your 10 minutes of rebuttal, or?
I certainly won't use that much, only to note that I know that Ms. Wiseman has been working for the store for some time. She filed an affidavit as the assistant manager in the court in May of 2018, and was part of the operations during the time frame that the court in July of 19 found that the business was operating in contempt of the court's injunction. I would just simply say that our request would be that the council would make a motion to adopt the written decision, which is on the left side of the binder. And I don't think I need to recount it, but each of the findings of fact it. Number one, that the claim of a business start date of September 13, 2019 is belied by the record because the court's injunction order says they started in 2011. Number two, the application contains the misrepresentation about business activity being a general retail, even though they continue to regularly feature sexual devices in the manner and in the location that was found unlawful by the circuit court on July 24, 2019. And then number three, the application contains a misrepresentation, false or misleading statement about the design for language on the packaging. The words designed for don't appear on any of the devices that our investigator purchased at the store last month, and said devices are clearly designed for sexual acts, and so trying to argue that they're not a sexual device shop by virtue of some packaging language is a misleading statement. Number four, Taboo's operation of a sexual device shop is unlawful and constitutes a nuisance in violation of 11-734A of the City Code, 17-374B of the Code, and 17-374C of the Code. And then finally, even here at the end of the hearing today, Taboo has not submitted proof that it has paid the $28,500 fine assessed against it for its business's illegal operations, which constituted contempt of the court. So, as the business license administrator or the business license inspector set forth in her letter under Section 11-35D, this application is due to be denied as well. So we would ask for the motion and for the written decision.
Okay, so pursuant to the hearing procedures, City Council may take the matter under advisement after the hearing or may vote upon the appeal at the conclusion of the hearing, which is concluded. Is there a motion?
The motion is to do.
I would like to say something, if I could. I didn't mean to.
Sure.
We believe that the business had notice because the notice of this hearing was hand-delivered to the store. And I think I would like to have Ms. Wiseman confirm that Greg Williams from the city's business license division did deliver a copy of the notice talking about this hearing being here today. If we could confirm that on the record.
Sure.
Obviously, because she's here.
Yeah, Ms. Wiseman, can you confirm that notice of this hearing was received?
Yes, ma'am. I was the person who received it. I was informed by Mr. White that he was not told he had to be here. But I can't speak for our lawyers or anything like that, but I can just say that he was not aware that he had to be here.
You, as assistant manager of the business, received notice of the hearing that was served on the business location?
As manager, yes, ma'am.
Okay,
And
thank
that
you.
And that was more than a week ago?
Yes, sir.
All right, thank you.
So duly notified, letter received.
Yes, correct.
All right.
Okay.
Madam
So
Pro
is there a
Tem,
motion?
I'd
Yes,
like
sir,
to
Mr.
make a
Fedora.
motion. I'd like to make a motion. I move that we affirm the decision of the business license official to deny a business license to Cricket Store 17 LLC ADB Taboo, and that we adopt the written decision tendered to us that uphold the business license denial because applying the standards of Chapter 11, Article 2 of the City Code, the record before us supports the license denial.
Okay, is there a second?
Second.
Okay, properly moved in second. Any discussion? Seeing none, if the clerk would read the roll.
Aye.
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 Thank you. Pursuant to the procedures, City Council will render the written decision based on the findings of fact and the standards of Chapter 11, Article 2 of the City Code, and that will be tendered to all parties. Is it proper to make a motion to adjourn, or so?
We would only ask that members sign here, the participating members sign this document, just one of them, the one that is in Ms. Devine's packet would be great.
Okay.
And then we'll make that the official written decision for the record.
All right, thank you.
Thank you.
Move to adjourn.
Okay, there's been a non-debatable motion to adjourn. Is there a second?
Second.
Okay, seeing that, if the clerk will read the roll.
Aye. Yes.
Aye.
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 And thank you all for